global webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM, here with a slight cold. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery. Today, it's called Important eDiscovery Case Law Decisions for October 2023, with our returning faculty experts, Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the Counsel, and questions will be answered both during and at the end of the webinar. And the webinar will be available for replay at your convenience for the next quarter, as are all our EDRM webinars. And we've got Kaylee Wallstad, EDRM's Chief Strategy Officer, here with us today. Kaylee, would you please tell us what resources are available?
Well, I absolutely will, and we have some spine-chilling resources available for you today. If you look in your console, you'll see a question mark. This is where you type in your questions for today's faculty. Slides will be made available after the webinar has concluded. You can click the paperclip for related content. You'll see today's resources. We have a download for On24's engagement tool descriptions that help you to better engage. A link to subscribe to eDiscovery Today's blog, and you won't miss a thing. A link to learn more about the Honorable Judge Peck and how to engage with him. And you can check out Tom O'Connor's spicy new book, eDiscovery for the Rest of Us. And then be sure to save your seat for next month's Case Law Edition on November 16th. And up next on EDRM's webinar channel tomorrow, October 25th, Declutter Your Data, Strategies for Efficient Data Retention and Risk Reduction. Speaker bios can be clicked and popped up to learn more about today's faculty. And just like Zoom, we have emoji and many of them. We really encourage you to engage and click and let our faculty know that you're enjoying the discussion today. Click the Twitter bird and you can follow EDRM and eDiscovery Today on LinkedIn. And back to you, Mary.
Thanks, Kaylee. And our faculty, we have Doug Austin, and Doug is the founder and editor of EDRM trusted partner eDiscovery Today. He's an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and government clients. Doug has published a daily blog since 2010 and has earned J.D. Super Awards 3 times. And Tom O'Connor, hailing from the great city of New Orleans. For over 3 decades, Tom has stewarded the Gulf Coast Legal Technology Center. And as Kaylee said, he's written a new book, eDiscovery for the Rest of Us, that you can find on his Techno Gumbo blog. And the Honorable Judge Andrew Peck is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters, and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first eDiscovery opinions, and then later on, adding to it with boilerplate objections, 502D orders, technology-assisted review, and more. And without further ado, Doug, do we have some cases?
We do indeed, Mary. Thanks, and hi, everybody, and welcome to our October 2023 Case Law webinar on the EDRM Network. If it seems like we were just here, we were just 20 days ago. Yet, like clockwork, we do have 6 new cases for you, including forensic protocol negotiation and scope, sanctions for plaintiff's attorneys in the Bob Dylan case, discovery issues identified during a bench trial, a voluntary waiver of discoverable materials, sanctions for spoliation of video evidence by NYC Department of Corrections, and a claim over the use of an emoji to influence stock prices. And just a reminder, we do welcome questions, and we'll try to get to as many as we can. And we'll send out a copy of the slides after the presentation, as Kaylee mentioned, so look for that too. And by the way, when you get that email with the slide, with a link to the slides, it'll also have a link to the 2024 eDiscovery Today State of the Industry Report Survey, which is now underway. So please consider taking that via the link in the resources. It literally takes 1 to 2 minutes, and you'll get a free copy of the report when it's published in January. So, and by the way, remember that graphic you saw on the title slide? It was generated by DALL-E 3 via Microsoft Bing. So generative AI is at our fingertips more and more every day. Of course, any ideas expressed by us here today are our own, not those of our organization's clients or partners. It may be true that the times they are a-changin', but the need to provide disclaimers never changes.
Oh, no.
Had to be said.
Oh,
and of course, before we get started with the cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 32,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. It's the definitive source for eDiscovery case law out there. So with that said, if I can find my mouse here, let's get into the cases. So we often cover cases where parties fall short in their discovery responsibilities and cooperation with their opponents, but this case had a pretty cooperative process. It involved claims that defendants stole plaintiff's trade secrets and confidential business information, where the district judge entered a stipulated preliminary injunction and required the parties to submit an agreed-upon forensic protocol after the parties identified the electronic devices at issue. The court also entered into the record a forensic protocol, which set forth a list of search terms to collect information from accounts and devices belonging to the defendant company and key individual defendants, and also entered into the record a protective order governing the exchange of confidential information. The parties conducted several meetings and status conferences until the only forensic protocol scope disputes remaining were the scope of search terms on additional custodians to be used moving forward, and whether any of the additional 22 proposed custodians should be subject to the forensic protocol. Regarding search terms, Louisiana Magistrate Judge Richard Bourgeois stated, the court agrees with ISG that for the purposes of searches for non-party custodians, the disputed search terms constitute generic file extension terms, or generic construction industry and contracting terms that are not reasonably tailored for discriminating between MMR's proprietary information and ISG's proprietary information. The court recognizes that many of these search terms were agreed upon by the parties for the purposes of the forensic protocol, which was originally designed to locate documents and information solely with respect to the original defendants. The amendment to the forensic protocol, which expanded the search to the additional defendants, did not modify the search terms. The expansion of searches to non-party custodians, however, merits a limitation of the applied search terms. So he decided to limit additional searches to the undisputed search terms identified in the parties' May 26, 2023 amended joint status report. As for the custodian's request, Judge Bourgeois stated, the court is not inclined to order searches of 22 additional non-party custodians, some of which were never employed by MMR. The court will, however, allow for a limited expansion of the custodians subject to the forensic protocol, which turned out to be the 5 individuals identified as the most important potential custodians by the plaintiff. So, Tom, does it seem to you that the parties really tried to work together and resolve as many disputes as possible before turning to the court, or that the court was very proactive in getting the parties to identify and resolve their discovery issues early, or both?
Well, a little of both, I think. I thought the court was very proactive. I mean, you had a stipulated preliminary injunction, a protective order, the judge being very proactive on the forensics protocol. I thought all of that went pretty well. And I thought the parties seemed to be cooperating pretty well at that stage of the game. Things kind of came off the rails, if you will, when we went from the forensics protocol to just let's start doing some regular old search terms on custodians. I get it. The plaintiffs, they came up with 22 new custodians after running the forensic protocol. Of course, the plaintiffs are going to want to explore all of those and see what they can find and dig deeper. And so the court had to get in the middle of that and did a good job, I thought, of refereeing that dispute as well. So, I thought this went fairly smoothly. with some pretty good hands-on refereeing by the court.
Yeah, really. I mean, this is kind of the way it almost seems like it ought to be. Yeah, you may have some disputes, but if you work together and resolve as many as you can, it makes a difference. And so, kind of an interesting case to cover from that standpoint.
Yeah.
So, Judge Peck, it seems as though the forensic protocol that the judge was expecting was designed to address forensic collection of devices as well as search terms agreed upon by the parties. In what types of cases is a forensic protocol like this necessary, typically?
Well, it depends on what one means by a forensic protocol. Mm-hmm. And I suspect Tom and Mary can add to this. But, it used to be that a forensic protocol or a forensic examination of a device or a system meant, a bit-by-bit image of, let's say we're talking a phone, a bit-by-bit image of everything on the phone. Now, that is rarely necessary, but I think without exactly knowing here that by forensic protocol, it was really an ESI protocol that the judge was using. Who are the custodians? What are the search terms? Are you collecting text messages or not? Things like that. And obviously trade secret cases where there is usually an allegation that a former employee now working for the other guy, loaded up various proprietary information onto their device before leaving the company and then went and started or joined another company. So there is much more quote unquote forensics involved in these sort of trade secret cases.
Yeah, and that's why I wondered if that was one of the reasons they called it a forensic protocol, is because part of it might have, entailed that level of collection, given the type of case we're talking about here. So, yeah, it's certainly interesting. It's not a common term I've heard used when talking about protocols, but certainly interesting to see how they went through the process here. So, Mary, as discussed, one of the things this case involved was negotiation over inclusion of custodians, which honestly I think is probably an underrated part of the process. So what recommendations do you have for a producing party to ensure the scope of response of custodians is appropriate?
Well, this case is interesting because some of the things I'm going to recommend, if you're producing your own material, that will not apply here, because here we've got over-inclusive non-party custodians, so you'd need cooperation with the non-party to do the things I'll be recommending. So the first thing to do for the non-party stuff is to get some costs, get some agreement on who pays, and that would probably limit some of that. But when you're looking at your own material, you want to see the extent of duplication across custodians, running your own exploratory searches across the custodian set, negotiate how many bites of the apple do you get after you agree to search terms. Look for the requesting party to stack rank or prioritize the custodians, because certainly in this case it stands for the principle that if you ask for a whole lot, you might get a little. Like they got their 5 priority custodians, and that was on the back of like one email. so I thought that was pretty amazing.
Yeah, absolutely. Yeah, you ask for a lot, you can maybe get, but what's the, it's, you can't get it, you can't get what you want, but if you try, you might get what you need. So there you go.
Oh boy.
Hey, speaking of musical references, let's move to the next case, which is one where the plaintiff alleged child sexual abuse occurring nearly 6 decades earlier and filed under the New York Child Victims Act. And the suit was against defendant Robert Allen Zimmerman, whom you all know better as Bob Dylan, and who responded to the lawsuit by calling it a brazen shakedown masquerading as a lawsuit filed in bad faith for the improper purpose of extracting a huge payout on the threat of negative publicity. On June 1st, 2022, one day after plaintiff's responses were submitted, defendant produced approximately 60 emails to or from plaintiff that he'd received during third-party discovery. As New York District Judge Catherine Fiala stated, the court has reviewed the emails, and without going into the specifics of their content, the court agrees with the defense that they call into question the veracity of plaintiff's allegations in her complaint. By the agreed-upon production deadline, plaintiff had produced only 49 pages of documents, omitting numerous emails that defense counsel knew existed because of their June 1 production. Then, after a conference of the parties led to new production deadlines being set by the court, plaintiff's attorneys claimed that they had been discharged by the plaintiff as her attorneys, but the defendant protested, noting plaintiff's noncompliance with the local rules of the court regarding attorney withdrawals. That led to another conference where the court made it clear to plaintiff's attorneys that it did not believe they had been discharged, that it recalled the commitments made and deadlines set just a few days earlier, and that it did not appreciate feeling as though it had been played. Sounds like a violation of Judge Peck's Rule 1.1 there. Ultimately, after consulting with plaintiff during a recess in the proceedings, plaintiff's attorney advised the court and defendant that plaintiff sought to withdraw her complaint with prejudice, leading to the sanctions motion by the defendant against plaintiff's attorneys, but not the plaintiff herself. In considering the sanctions motion, Judge Fiala stated, plaintiff and her attorneys lobbed heinous accusations of sexual abuse at defendant, prompting widespread news coverage of her lawsuit. And yet, plaintiff refrained from producing nearly all of her responsive materials in discovery, and what evidence the court has seen thus far undermines plaintiff's allegations. Defendant has been forced to expend substantial sums of money in litigation defense costs. In granting the motion for sanctions in part, Judge Fiala stated, the court finds that the attorney's noncompliance was willful. However, the two plaintiff's attorneys were sanctioned $5,000 and $3,000 respectively, not the $50,000 that the defendant sought. As Judge Fiala stated, the court observed firsthand the challenges that plaintiff posed as a client and is confident that plaintiff's attorney's noncompliance is at least partly attributable to her. While it might have behooved everyone in this litigation for plaintiff's attorneys to have conducted a more robust pre-suit investigation or to have ensured ex ante that plaintiff understood and was willing to comply with their discovery obligations, that is beyond the scope of this Rule 37B motion. By the way, hat tip to Michael Berman for coverage of this case on the EDRM blog. So, Judge Peck, it seems like we're seeing more sanctions through Rule 37B these days. Do you think the parties are looking to push for court orders that could lead to sanction if their opponents fail to comply?
Yes. We know that if it's the destruction or spoliation of ESI, the Eric Mandel flow chart of the steps you have to go through to get sanctions under 37E, it's a lot of steps.
Right.
37B is nice and simple. The court ordered you to do X. You didn't do X, pay up. Sanctions to be imposed. So, it's one of the things we've talked about in some of the other cases we've covered over this year. If you have an ESI protocol and it becomes an order of the court, you better make sure that whatever you've agreed to do there, you're going to do. Otherwise, you're in 37B sanction land. So, be careful what you're agreeing to in things that become a stipulation and order as opposed to just a stipulation. It's one of the reasons, frankly, that I never liked when parties came to me with a proposed preservation order, because it then takes it from 37E and the general law on what you have to do to preserve and not preserve, et cetera, to a court order saying you must do X, Y, and Z, and if you don't do it, there can be sanctions. So again, be careful what you're agreeing to with respect to STIPs and proposed court orders.
Yeah, absolutely. And since I alluded to it, and I know a lot of folks probably are here month after month, but for any of our new listeners, what is Judge Peck's Rule 1.1?
That's easy. You're not going to find it in the rule book. Rule 1 is the just, speedy, and inexpensive application of the rules. Rule 1.1 is don't piss off the judge by your conduct.
There you go. And obviously that seemed to have happened here. So Mary, I mean, given that they had a difficult client, should plaintiff's counsel have even taken this case at all?
Well, mentally ill people deserve representation.
And fair enough. Whoa.
And the judge said it was a kindness, not to ask for money from the plaintiff. And as I read that, I thought that there was, concern about her mental health. But generally, at the beginning of an engagement, of course, to do a pre-suit investigation, but simply if there's proof and it's in documents, the attorney should be able to see it early and make an assessment on whether or not the evidence is going to stand up. And then there needs to be some language in engagement letters about what the expectations are and when an attorney will ask to withdraw or, by contract be allowed to withdraw, of course, with the court's agreement. And the client needs to be counseled on preservation, and there needs to be some oversight and follow-up. And I really don't understand why she had documents and they didn't get produced. That to me is a mind boggler.
Right. Well, unless you just didn't want to produce anything that hurt her case, which it sounded like ultimately were produced by other folks. So
there you go.
Yeah, that would certainly seem to be a reason, a logical reason anyway. So certainly, Tom, the defendant didn't get the entire amount they were seeking. So were the sanction amounts sufficient, given the statement from the judge that defendant has been forced to expend substantial sums of money in litigation defense costs? And this is for a case that ultimately was found to lack merit.
Well, I mean, on the face of it, you'd say no. This one, as with Mary, this was a head scratcher to me. It was almost as though something was happening here, but I didn't know what it was. And it was just, the judge was clearly exasperated, referred to the empty head, pure heart justification for the lack of productions, complete neglect of all deadlines, and a failure to respond to motions and court orders. At one point in the order, the judge said, "For the love of God, produce these materials."
Right.
I mean, you're thinking to yourself, man, we were talking baseball earlier. I'm waiting for the big curveball to break across the plate. And then the judge comes in with this minor thing saying, referring to the emotional state of the client. And he did note that when determining the appropriate remedy for violation of Rule 37B, a court should impose the least harsh sanctions that will serve as an adequate remedy. I guess given the fact that the case was dead, maybe the judge considered this the least harsh sanction to serve as an adequate remedy. Mm-hmm. I guess.
Yeah. In addition, we talked about this when we talked about the Avianca ChatGPT case. It may not be a lot of money, although the court did note that both of the lawyers were solo practitioners, to whom presumably $5,000 or $3,000 is a lot of money.
Right.
But it's also their reputation. I can almost guarantee you that in every case going forward, opposing counsel are somehow going to work into their brief on any motion. Attorney X, who was sanctioned $5,000 by Judge Fayella in the Bob Dylan case, blah, 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 continues, the misconduct or whatever it may be.
Right. Good point.
Oh, that's a great point. Yeah. That's for in the Avianca case, that $5,000 was a drop in the bucket compared to him being discussed in every conference I've been to over the past 6 months. So yes, sometimes it's not the amount, it's the fall, it's the blowback after. So indeed. So our next case is unique in a handful of ways. For starters, look at the case style. It doesn't come from any of the 50 states or DC or Puerto Rico or even Guam. Yet it's still a U.S. case from the Northern Mariana Islands, which are a U.S. Commonwealth in the Pacific Ocean. Another thing unique about this case is that no issues regarding discovery were raised, apparently, until the bench trial, during which testimony revealed relevant documents that plaintiff did not produce, including spreadsheets tracking work performed by its subcontractors, employment records such as timesheets, payment information to employees or subcontractors for work performed, and documents relating to subsidiaries and affiliates of the plaintiff. Although the defendant moved to dismiss the case based on these deficiencies, the court denied the motion and instead ordered plaintiff to produce all additional responsive materials by August 12, 2022. Of course, they produced some materials, but defendant argued plaintiff had fallen far short of complying with the court's order that it produce all responsive documents, and multiple status conferences failed to resolve the issues. Those ongoing status conferences culminated in defendant's oral motion for sanctions in the form of dismissal in December 2022, which was granted. Another unique thing about this case was that several of plaintiff's witnesses testified remotely from locations within China. The court sua sponte raised the issue of whether remote testimony of witnesses located from within China constituted a violation of Chinese law, and if so, what the appropriate remedy should be, which became somewhat moot, but was still addressed by District Judge Ramona Manglona in her ruling, where she stated, "The court finds that the discovery IPI seeks is not only relevant, but critical for Sardini to establish liability and for IPI to mount its defense thereto. However, due to Sardini's delayed and incomplete discovery materials, Sardini cannot reasonably expect to meet its burden of proof or allow IPI to present a meaningful defense. IPI is therefore prejudiced without such relevant discovery. While Sardini may not be faulted for the non-cooperation of other entities, Sardini can and is faulted for failing to preserve these records in the first place. It appears that Sardini did not engage a financial expert witness to sort all the financial documents, and it did not see the need to offer such testimony at trial because no financial expert witness was included in Sardini's witness list. It does not appear that Sardini could recover from these discovery mishaps." So she granted defendant IPI's motion for sanctions pursuing to FRCP Rule 37B and 37E and dismissed the case with prejudice. Additionally, regarding the parties' arguments on the applicability of Article 284 of the Chinese Civil Procedure Law as to trial testimony taken from witnesses in China, Judge Manglona stated, "It is not that a party's trial testimony would unquestionably violate the law. It is that a party's trial testimony would unquestionably violate the law if the party did not get authorization from Chinese authorities as the Hague Convention prescribes. In summary, reading Article 284 and the Hague Convention in tandem, testimonial evidence from witnesses in China may be acquired if the proper procedures are followed, i.e. the procedures in the Hague Convention." So something to file away for future reference there. So, Mary, it seemed like the case was moving along until the bench trial began and the plaintiff discovery deficiencies came to light. How could the defendant, and the court for that matter, have fleshed these issues out sooner before the bench trial began?
Well, of course, good pleadings, a meaningful meet and confer, and then at the meet and confer, in this case, sequence the China data to give the case team time enough to get authorization or find out what additional process needs to be done for that particular data. The other thing that can be done is at the meet and confer to set up a test production just for format, and then you'd get a good glimpse of what metadata is included. And then, of course, as Judge Peck said, depending on which side you're on, at the scheduling conference, you either have a stipulation or you have an order, and depending on where you're at in that. And to do a case management or early case evaluation on what you have, and then import the productions when you get them. Don't let them sit on the shelf for 6 months or even 6 weeks. Get them into your system, make an assessment. Do they load just from a technical standpoint, but then assess them for gaps in dates or data types or custodians or corrupt data. I think it's really important to do that.
Yeah, all great suggestions, and definitely would have helped flesh out those issues in this case certainly sooner. So, Tom, are you surprised that the court didn't go with a lesser sanction here, like an adverse inference instruction, to at least provide an opportunity to decide the case on its merits?
No, not really, given the timeline and the events. I mean, this had dragged on. It took 2 years to get to trial, so there was adequate time for discovery. Then they start the trial and find out that documents hadn't been produced. The court ordered them to produce them, and it seems like they didn't. The defendant argued the plaintiff, as you quoted, had fallen short of complying with the court's order. It seems to me this was an ongoing violation of Judge Peck's Rule 1.1. I think the judge probably just ran out of patience here, especially in the middle of a trial. Mm-hmm. I don't know, maybe there's a little less patience in the Northern Mariana Islands. I don't know.
Their docket is so heavy there.
That's right. That's right. As opposed to no. Does anybody know what the Southern Mariana Islands are?
Well, I think Guam is technically considered one of those. So
you are correct.
Yes,
you are correct. So, Guam has its own court, so that's right. To distinguish. So to Judge Peck's point, you would think the docket is not exactly overwhelmed there, but I just think that the judge just ran out of patience with these people.
Yeah, perhaps. Well, I mean, if you look at the case citation, it's case number 00007. So I don't know what that implies there, but yeah, you wouldn't think they would have a ton of cases in their courtroom, but who knows? So one of the things, of course, Judge Peck, I noted was the Chinese testimony consideration here. So did you ever have a case involving testimony from witnesses in China and have to address an issue like the one in this case? And also, should the judge here have even let those witnesses testify in the first place?
Well, I hate to criticize another judge, but this whole thing of having a bench trial and discovering all of these problems in the middle of it is, in my view, poor case management. I mean, generally, as a judge, what's going to happen in the bench trial. You have a pretrial order submission from the parties listing their trial exhibits and their witnesses and various and sundry other things. I don't know if because this was a bench trial, everybody was flying by the seat of their pants, including the judge as well as counsel, but that's one answer. I'd also add the word bench trial here, which I think goes, Doug, to what kind of adverse inference would there be?
Oh, well, yeah, of course.
Judge would instruct himself, to think about this. I think, let's just cut to the chase. And as much trouble as we have trying to get discovery from Europe without violating the GDPR, you ain't seen nothing yet till you have to deal with Chinese state secrets and other forms of Chinese privacy law. Did not have it when I was on the bench, had it in a case I was consulting on here. And it was sort of you got to give up at some point and just say it's not going to happen. Yeah, certainly.
And I feel a bit sheepish for the adverse inference question on a bench trial. So definitely kind of like should have thought that one through a little bit more. But yeah, certainly there were some interesting aspects to this case, and it was unique. So definitely one I thought we should get into a bit. So we'll get into our next case, for which there might be a room for quite a bit of second guessing. It involved the plaintiff's claim of misappropriation of trade secrets, breach of contract, unfair competition, and more against two former employees who left the plaintiff company and formed a competing company. Plaintiff moved to compel discovery of their text, social media, and LinkedIn messages for the 3-month period before and after forming their competing company in July of 2020. During document production, one of the defendants, Mr. Mallon's emails with market group clients allegedly indicated that communications were made over LinkedIn and text. Plaintiff also argued that these communications were patently relevant to the prosecution of their case to likely reveal which clients Mr. Mallon and Mr. McArdle contacted and attempted to solicit, as well as any other discussions of improperly removing and using markets group confidential materials, and more narrowly tailored to the needs of the case, as the 3-month scope of its demand is limited in nature and does not constitute a fishing expedition. Sounds reasonable, right? Here's the problem. Defendants opposed the motion to compel, arguing that the terms of the ESI stipulation signed by the parties prohibited disclosure. Defendants submitted that plaintiff's counsel stipulated to not request text messages in the ESI stipulation and argued that this demand was untimely, given that it came more than a year following execution of the ESI stipulation. For defendants, the stipulation, like any contract, requires the court to adhere to its terms absent fraud, collusion, mistake, or accident. And for good measure, defendants also characterized plaintiff's request as overly expansive and speculative, but they didn't need that argument. New York Supreme Court Justice Robert Reed stated, defendants are correct. Plaintiff was represented by counsel and consented to a voluntary waiver of discoverable materials when it stipulated that the following sources of ESI information do not warrant collection, search, review, or production: voicemail, text messages, personal phones or tablets, and instant messages. Plaintiff has made no showings of fraud, duress, coercion, or mistake warranting this court overturning the stipulation. Accordingly, plaintiff's motion to compel is denied. Big ouch. So, Tom, would you consider agreeing to such a restrictive ESI stipulation here to be malpractice on the part of the plaintiff's attorneys?
Well, you know, that's tough. You know, malpractice was the decision below the accepted standards of professional preparation. You know, your first paragraph on the slide says that they clearly had focused in on the emails, and that all the breaches of contract were demonstrated by documents showing the formation of the company while still employed, blah, 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 the downloading. You know, they seem to zero in on the emails and thought that that's where everything was going to be. Is that foolish or misplaced and ignorant? Yeah, probably all of the above. Mm-hmm. But does it rise to the level of negligence and malpractice? I just don't know. I'd like to hear the judge's opinion on that one, because I'd have a tough time of going quite that far.
I'm going to throw out something that they may have been extremely effective representations. I mean, here, yes, it's the plaintiff, but the plaintiff is the company, the bigger company. And I could see plaintiff's counsel saying, you know, every time somebody asks for texts and voicemail and yada, 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 you know, we're a big company and it drives us crazy. So let's stipulate that neither side, and I'm assuming here, although it's not clear from the opinion, that this was a neither side gets voicemail, texts, et cetera,
right.
et cetera. Sure. So there could be a very good reason for a corporate counsel to take that stuff off the table.
Yeah, good point.
But in a case like this, where you would think there would be more likely to be side conversations in other platforms, wouldn't you think this would be a case where they should have thought maybe, oh, you know, we need to keep things open to go after whatever communications they might have had?
Yeah, I mean, you know, that is the problem with these sort of protocols. You try to lock something in or lock something out in this case, and then it turns out you really need it, but you traded it away.
Yeah, absolutely. Well, so, I guess, as a judge, were you ever inclined to give a party a break when they made a mistake this egregious, or is a deal and they're stuck with it?
You got to be careful in that sort of stuff. Did I ever, think about putting my thumb on the scale somewhere? Probably. But the question is, when and where do you exercise that discretion, if it's even discretion? If one side hires a DLA piper and the other hires the ChatGPT counsel as a judge, do you say, that's not fair? Or, yeah, okay, these people made a mistake and let's help them fix it, or it is what it is. I can't say I never exercise some discretion there, but a judge has to be careful in leveling the playing field like that.
Yeah, sir. Yeah, I can imagine. So, as Judge Peck alluded, Mary, to keep costs down, sometimes it does make sense to agree not to produce certain types of ESIs. So what can parties do to make sure they're not including ESI types that could ultimately prove to be important to the case?
Well, the first thing is to know what data you have, data maps, and how easy it is to find and to produce the data that you have. And then also to understand the communication channels of your witnesses and the witnesses on the other side. And then before offering to exclude, look at the data, or at least a sample of the data, and see if there's anything in there for your claims, defenses, and then also for impeachment. You can certainly run search terms against it, put it into tar, and then certainly never agree to screenshots without the ability to ask for metadata or the original.
Yeah, those are all great suggestions, and certainly one of those things where having a stipulation that excludes certain types of data, you definitely want to make darn sure that's not going to be important to the case. So yeah, this was an interesting. It was a short ruling because there wasn't really much to rule on, and it was certainly impactful. So we'll move on to our next case, which was related to an incident that occurred on September 10th, 2015, when the plaintiff was incarcerated, and that incident escalated to a point where the plaintiff was hit in the face. At some point during the altercation, or maybe just after, a New York City Department of Corrections probe team arrived, including an officer who operated the handheld camera during the alarm. The captain there, David Levy, testified there was a probe team that went down with a video camera, but at that point the use of force had already occurred. There were conflicting reports about the existence of the video, with Levy having stated at one point he reviewed the video, but testifying later that he didn't view it. Regardless, on October 6, 2015, the Legal Aid Society sent a letter to DOC on behalf of the plaintiff requesting an investigation into the incident and asking DOC to confirm that the department will take steps to preserve all photographs and to properly investigate Mr. Castro Martinez's allegations. Also on October 28, 2015, plaintiff also submitted an inmate grievance and request program statement form to DOC. Despite that, defendants produced a declaration from DOC which stated that there is no record of any video on September 10, 2015 at or around 11:10 a.m. and if the video is not stored on the DOC server, it would have been deleted automatically. In September 2015, DOC standard procedure was that all handheld videos were automatically deleted within 90 days unless they were marked to be preserved by the facility if the handheld recording device captured the actual incident of a use of force. In considering the issues, New York District Judge Jessica Clark found that the factors weigh strongly in favor of finding a special relationship between defendants and DOC, and that DOC's and defendants' interests are sufficiently aligned and closely interrelated such that imputing DOC's alleged spoliation to defendants is appropriate. Judge Clark also rejected defendants' claim that the relevant video footage never existed, and their argument that even though Story's report indicates that she operated the handheld camera during the alarm, that does not prove that the camera was turned on, stating Story's report indicates that she operated the handheld video camera during the alarm. It defies logic to understand operate in this context as meaning something other than creating video footage. As a result, she stated, plaintiff has demonstrated entitlement to sanctions pursuant to Rule 37E1, as plaintiff has both met the threshold requirements of Rule 37E and has been prejudiced by defendant's spoliation of evidence. While not finding intent to deprive, but negligence instead, Judge Clark ruled plaintiff will be allowed to present evidence to the jury that video footage existed that would have shown, at a minimum, the aftermath of the incident and that the video was deleted by DOC despite the department's obligation to preserve it. This sanction will allow plaintiff to inform the jury that this relevant evidence once existed and thus remedy DOC's negligence in destroying the video. So Judge Peck, doesn't granting permission to present evidence that the video was deleted have about the same effect as a permissive adverse inference instruction on the jury?
Yes and no. I mean, when the judge tells the jury something, generally the way the adverse inference would work, you know, the judge is an authority figure to the jury and usually somebody that the jury identifies with, likes, et cetera, et cetera. So the judge could just say, you know, ladies and gentlemen, you should know that there was a video, it doesn't exist anymore, and you can, but you don't have to infer from that, blah, blah, blah. It's different than the plaintiff's counsel having to figure out how to get that in evidentiary form in front of the jury. It's close, but an adverse inference instruction probably would be more powerful.
Yeah, certainly. I guess I was a little surprised that she did allow them to present the information since there wasn't considered intent to deprive. So I was curious your thoughts on that. So one of the things I found interesting about this case, Mary, was imputing DOC's video spoliation to the defendants, which were two of the officers involved in the, in the incident. They were. So, do you agree it was right to do so because they weren't technically the ones in charge of that evidence?
I think the operative word there is technically in charge of the evidence. What I've seen, and it's anecdotal, is that when you're looking at the government, it's like even though there's departments and there's rivalries and there's budgets and everything, it seems to be more likely that the government will be held to the standard that, those other departments, you have a sufficient alignment of interest. Where corporate wise, sometimes it is, sometimes it isn't. But I think that, and here too, you've got a vulnerable population, and even though it wasn't written that way, I think that might have factored into it as well.
Sure. Yeah, well, that certainly makes sense.
I would just add, as somebody who, supervised discovery and tried some of these cases, the department is generally dismissed from the case at the summary judgment stage, sometimes even earlier. So technically, they're not even going to be a defendant at the time of trial. But the individual correction officers, and one could say the same about individual police officers and their video, they're not supposed to be, in charge of what happens to the videos. They give it to the powers that be. And if one didn't say that Doc was aligned in interest with the defendant officers, then there could never be a spoliation sanction issued effectively against any defendant in these cases.
That's that's good we have you here because you've got that perspective. So yeah, absolutely. Great point, and very interesting. So Tom, so what do you make of the defendant's argument that operation of the camera doesn't prove that the camera was turned on? Was that a grasping at straws kind of argument?
More like Jack grasping at the floating door in the water at the end of Titanic, I think. It actually, the first thing that came to my mind was Bill Clinton arguing on what the meaning of the word is in his deposition, and Bill Gates arguing over the meaning of virtually every word in his deposition years ago during the antitrust case. No, as the judge said, you quoted it above. It defies logic to understand operate in this context as meaning something other than creating video footage. That's it. End of discussion.
Yeah, yeah. Seemed like a silly argument to make. So, yeah, and the judge dealt with it appropriately. All right. So our last case comes with a picture, and it gives us a case for the second month in a row where an emoji is important to the issues. In this case against Bed Bath & Beyond, its CEO and investor Ryan Cohen over alleged pump and dump scheme to inflate the value of the stock before selling. Cohen, who had previous investing success with GameStop and others, you may remember that frenzy a couple of years or so ago, bought a 9% stake in Bed Bath & Beyond, and with this leverage, he made public business recommendations and picked several members for its board of directors. After a series of bad news announcements for Bed Bath & Beyond, CNBC tweeted a negative story about Bed Bath on August 12, 2022, accompanied by a picture of a woman pushing a shopping cart. Cohen responded with the tweet you see here. Innocent, right? Well, as DC District Judge Trevor McFadden stated, some online communities understand the smiley moon emoji to mean to the moon or take it to the moon. In other words, according to plaintiff, Cohen was telling his hundreds of thousands of followers that Bed Bath's stock was going up and they should buy or hold. They did so, sending the price soaring. Cohen ultimately made out handsomely when he sold a few days later, profiting $68 million, which eventually led to the suit when the stock plummeted a few days after that. The parties, including Cohen, moved to dismiss, and the court addressed each claim to determine whether they would survive or be dismissed. Regarding Cohen's objections that emojis can never be actionable because they have no defined meaning and that emojis are at the very least ambiguous, Judge McFadden stated, emojis are symbols. Like symbols, language can be ambiguous. If you say the Nats are going to win the World Series this year and your friend replies right, she may be agreeing with you, but it could also be a sarcastic reply. Same could be said for my Astros, evidently, but I digress. Context and tone help elucidate meaning. Just because language can be ambiguous does not mean it is not actionable or capable of being correctly understood. He also used an example of a steak emoji in response to a dinner request as either meaning the respondent wanted to go to a steakhouse or grill at home, depending on context. Judge McFadden stated, the questions here thus become, has Bratya plausibly alleged that the moon emoji has a particular meaning in the context in which it was used, and if so, is that meaning actionable? Regarding the first question, Judge McFadden stated, Bratya has plausibly alleged that the moon tweet relayed that Cohen was telling his hundreds of thousands of followers that Bed Bath's stock was going up and that they should buy or hold. In the meme stock subculture, moon emojis are associated with the phrase "to the moon," which investigators use to indicate that a stock will rise. Regarding the second question, Judge McFadden stated that meaning is actionable. For one, it is plausibly material. That is, there was a substantial likelihood that a reasonable investor would consider it important. Investors appear to have relied on it, driving Bed Bath's stock price up in the following days. So he denied the request to dismiss the claim over the moon emoji tweet. By the way, hat tip to David Horgan on this one for his coverage of this case in a couple of conference sessions I attended with him at conferences. So Mary, we've seen a few cases recently with emojis that have had a significant impact on the case. But eDiscovery workflows involving emojis aren't highly standardized. So what recommendations do you have for our audience on how to handle emojis in the eDiscovery?
Well, this is a great one, and I saw that one. And I just thought, to the moon, Alice, but that's not what it means.
Right.
Not at all. It's the GameStop meme pump and dump, and there's emojis all over the place, and so they need to be screened and reviewed for the particular meaning and context, and then impact to the case. And I'd suggest pre-categorizing it so that people that are experienced with the emojis can determine whether or not the material's responsive. And then educate oneself on the varieties of the same emoji and how they look on different devices, as well as the meaning across different cultures. I think that's really important. And my goodness, you just look at this case and it's a $68 million windfall. It was really something to watch it in the news.
Yeah, absolutely. And yeah, those considerations, across the devices, across the cultures, a lot of considerations there. So it's going to be really interesting to see how this discovery of emojis evolves, because clearly we're seeing more and more cases that involve them as part of the discoverable evidence there. So so certainly, Tom, so far the claim regarding the moon emoji tweet has survived as actionable. So if you were involved with this case, what electronic evidence would you pursue to demonstrate that the investors acted based on that tweet?
Well, two things I'd look at, or initially look at. One you touched on, which is the in the meme stock subculture, moon emojis are associated with the phrase to indicate that a stock will rise. So the judge actually went on to say a little bit after that snippet that you quoted, quote, for example, one investor replied to Cohen, subquote, buy $BBBY, got it, thanks, end quote. So I'd want to look at replies. I'd want to look at the, whatever we've got for all of the messaging that went on here, and see how many people replied affirmatively to that indicated that that's exactly how they were interpreting the emoji, as this one person that the court quoted did. And then the second thing, if we can get at it, is to look at actual purchases. What happened after he sent that out? Did the stock go up? Did people start to buy a ton of it? I mean, let's look at the stock history of purchases in the immediate aftermath of that message, and see if we've got some electronic information that will show that the message was received and understood, and a lot of people went out and bought.
Yeah, absolutely. And probably timing is important too, because I actually, out of curiosity, decided to pull up his account and go down to that time period to see if that tweet was still there. And amazingly, it's gone, surprisingly. So I can't imagine why. So yeah, so timing is of the essence as well. So, but obviously these things get captured for posterity all the time. So yeah, definitely a consideration there. So Judge Peck, we've seen this case and the recent case in Canada where a thumbs up emoji was ruled to be acceptance of a contract. So what evidence would you expect from a party to rule on whether an emoji could be interpreted as claimed by that party?
It may be that some emojis are sufficiently common sense. Yes, a thumbs up generally means yes in some way. But I think otherwise one is going to need expert evidence or emoji evidence, so to speak, of what does the full moon emoji mean in the meme stock community. I mean, I don't even know what the meme stock community is, let alone how they view certain emojis, but I think that is going to be a field for expert or factual testimony. Might be somebody in the meme stock area saying, oh yes, I and my friends all know what that means. Okay, what's it mean? It means, buy. But I think to expect judges to know what all emojis mean to different communities and different ages, like how many in the audience below a certain age understood Mary's comment about to the moon Alice, referring to the old
Right.
Jackie Gleason Honeymooners series. You know, there's context around everything.
Sure. Yeah, absolutely. So yeah, very fun case, very interesting case. So now we are at the top of the hour, so perfect timing. I don't think we've ever timed it so this perfect before. This is the contacts page, and we do have another case law webinar coming up on Thursday, November 16th. This time I have a whole 23 days to cover 6 more cases, which almost seems luxurious as compared to last time. And Judge Peck's already given me 2 of those, so I've got a good head start. So again, I will, with that, I will say thanks to Mary, Tom, and Judge Peck for their terrific insights as always. And I'll turn it back over to you, Mary, to wrap us up.
Oh, thanks, Doug. And EDRM thanks you, of course, for anchoring Doug, and Tom O'Connor and the Honorable Judge Peck for this insightful presentation. And our thanks to the EDRM community for your kind attention. We'll see you next time on the EDRM Global Webinar channel. Thank you.
Bye. Thanks, everybody.